Hi, my name is Putra Ani Izzuddin Bilwan from class CFFP 1142C. My metric number is 2024295678. My character is Master Adam, the owner of Borneo Souvenir Shop.
Hi, my name is Dayang Ajarna binti Abang Ismail from class CFFP 1142C. My metric number is 2024297152, and I'll be playing as Mr. Adam Lawyer.
Hello, my name is Nur Shafika. I'm from CFFP 1142C. My metric number is 2024415666. I will be playing Miss Rina, which is I owner of Sarawak Layer Cake.
Hi, my name is Nur Syuhada binti Muhammad Rizwan Nur Rahman. My matrix number is 2024419148. And my class is CFAP 1142C, and my character is Mrs. Rina Lawyer.
Yes, Lina, we need to talk about this issue right now. Your site is now taking up even more into my space. That is 4 inches into my space. You have the right to put it there.
Mr. Adam, it's just a science. It's not even touching the ground. It's been there for years. Why make it a problem now?
That was before, but now it's more obvious. Even if it does not belong anything, that space still belongs to me. Just because I did not say anything earlier does not mean you can take more now.
There's money in that science. I'm not removing it just because you suddenly change your mind.
The last one is 4 inches, and I'm still keep quiet. But you went ahead and installed a bigger one. You were asking me first, and I'm ready to give a written notice to remove it, but you ignore it. I think it is a trespass.
I did not ignore it. I just don't think it trespass. It doesn't block your shop or cause any damage. It's been there for years without any issue.
That's it. I had enough time taking this case to the court. It is trespass and ready to prove it.
Fine. If that's how it has to be, let the court decide. I will bring my lawyer.
Your Honor, I rise today on behalf of my client, Mr. Adam, the owner of Borneo Souvenir Shop located at Waterfront Kuchi. For many years, he has been a good neighbor to Miss Rina, who owns the Asian cake famous for its Sarawak layered cake. However, we are today because of a clear airspace of trespass. Let me outline the facts. Originally, Miss Rina had a signboard that intrudes 4 inches into my client's airspace. Recently, she replaced the sign, which now intrudes 8 inches without any concern. After giving notice to remove the sign, Miss Rina refused to comply. As a result, Mr. Adam is now seeking an injunction to remove the sign. Under the law, trespass to land includes unauthorized physical intrusion into airspace, particularly when it interferes with the land's owner, use or enjoyment of his property. Refer to Bernstein v. Skyview 1978, a property owner has rights in the airspace above his land to extend necessary for the ordinary use and enjoyment of his land and structure. This 8 inches intrusion interferes with my client's right. It is not trivial, it is unlawful. Therefore, I respectfully submit that the court should recognize this as trespass, grant an injunction for the removal of the signboard, and consider damage if necessary. We do not seek conflict, only the enforcement of legal rights and property aspect. Thank you.
Your Honor and respected audience, I represent Ms. Rina, a hardworking entrepreneur who has proudly operated her cake business at Waterfront Kuching for many years, growing tourists and customers alike. While we do not deny the presence of the signboard above Mr. Adams' premises, we must understand the context first. The original sign has been placed for years. With Mr. Adams' knowledge and no objection has been made, the new sign may extend slightly more into the airspace, but it causes no damage, no obstruction, and does not interfere with Mr. Adams' business activity. The sign is located high above ground, and the concept of trespass must be reasonable. Let us refer to Kelson v. Imperial Tobacco CO 1957, where a signboard hanging a few inches into another airspace was deemed trespass. Yes, but the case involved direct interference. In this situation, we argue that the increase from 4 to 8 inches is minor and not a material changes. Mr. Adam's delay in objecting over the years shows implied consent. This sign brings value to both business by attracting customers to the area. Additionally, an injunction is an equitable remedy. It should not be granted when the interference is minimal and when no real harm is shown. We therefore request that the court dismiss the injunction, encourage both parties to resolve the matter amicably through discussion, acknowledge no malicious intent on the part of Ms. Rina. In conclusion, let us not escalate a minor matter into a major legal conflict. Ms. Rina is open to discussion and solution. Thank you.
Notice of application for injunction. Take notice that the plaintiff applies to this honorable court for the following orders: that the defendant remove the signboard which encourages 8 inches into the plaintiff space located at waterfront Kuching within 40 days from the date of this order. That the defendant be restrained from placing or restraining any structure that intrude into the plaintiff airspace, whether express permission. That cost of this application be borne by the defendant.
I would like to briefly offer an advice on a matter involving Mr. Adam, the owner of a shop in waterfront Kuching. A signboard belonging to his neighbor, Miss Rina, was replaced and now extends 8 inches into his airspace. While the previous sign had also encroached slightly, this new extension raised potential legal concerns, particularly under property law. In general, landowners do have rights over the airspace above their property, so any unauthorized structure, even a sign, may be considered trespass. Since Mr. Adam has already given notice and received no response, he may want to consider legal remedies, such as applying for an injunction or alternatively try to reach a peaceful resolution. Thank you.
Dear audience, from this case, we can learn a few important things. The first one is, not all small problems need to become a big legal issues. It's better to talk and find a peaceful solution for it. Second one is, if something has been there for a long time without complaints, it may mean that both sides have accepted it. The third one is, the sign didn't cause harm, so it's fair to say it wasn't done with bad intention. And the fourth one is, the law should also be fair, not just strict. If there is no real harm, we should look for a fair outcome. Also, small business like Miss Rina help bring life to the area. Instead of fighting, we should support each other and solve problems in a good way. Thank you.
In conclusions, the dispute between Miss Rina and Miss Adam clearly involved the thought of trespass, specifically trespass to land through a space enlargement under the law of thought, even a minimal intrusion into another property without consent, including a space, constitutes a trespass. Despite the sign being affixed for years, the extension to 8 inches worsens the situations and supports Mr. Adam's right to seek legal remedy, including an injunction. Ms. Rina, therefore, must recognize that continue the enlargements without permission is unlawful and legal action by Mr. Adam is justified. Thank you.